everybody, this is Frekhtman, a New York City personal injury trial attorney, and today we're talking about soft tissue cases. So what I want to discuss in this video are the types of soft tissue cases, usually car accident cases or car crash cases that people suffer soft tissue injuries. What are the types of soft tissue injuries? Next, we're going to talk about symptoms, and then does the crash itself cause the soft tissue injury as opposed to another cause, right? What is the cause of the soft tissue injury? And next, I want to give you some of the defense playbook, some of the defense arguments about soft tissue cases that are persuasive, and then how the defense, the insurance company or the defense lawyers hired by the insurance company, how they use this playbook and these arguments to destroy cases and to get defense verdicts, meaning that injured plaintiffs don't get anything. And then maybe we could touch on some ways to counteract that as well. Okay, so let's get started. So number one, what is a soft tissue injury? Well, fundamentally, there are really two types of soft tissue back injuries. Number one, you could have whiplash, when your neck gets whipped forward and then back in the car after a crash. Or you could have an actual disc pathology, an actual injury to the disc known as either a bulging disc, where the disc bulges out, or a herniated disc, where the annulus fibrosis or the outer shell, outer lining of the disc, outer layer breaks, and the liquid inside the disc leaks out and then touches those nerve roots, and that's what causes the pain. So those are the two types of injuries. Either you have bulges or herniations, which are diagnosed by MRI, magnetic resonance imaging. That's a radiological test. Or you could just have whiplash. Whiplash itself could also be a serious injury because all those ligaments in your neck that hold up your head get injured, and then, it could be a serious injury. So one of the things that, I learned about soft tissue injuries is that if the symptoms last longer than 6 weeks, it's unlikely they will ever go away on their own. And so if you have these symptoms for more than 6 weeks, even if it's considered soft tissue, they may not go away on their own. It's unlikely that they will. And then you may need some kind of, treatment, either epidural steroid injections, percutaneous discectomy, perhaps some kind of just physical therapy, but it's not likely to just go away on its own. And so the next thing that's important to consider is, did the crash, the traumatic injury, did that cause the herniation, the bulge, or whatever your diagnosis is, right? And so when you look at causation, there's really a number of factors that you have to look at. Number one is the patient's age. Number two is, when was the onset of pain? Number three, the past medical history. Have they had these same types of symptoms or same types of injuries before? You have to look at past medical records. It's very important to get past medical records if they exist, because very often a person may forget that they had past medical care, or they might have past medical care where they just mention like pain to the neck in conjunction with something else. Like you can have a cough and just mention, pain to the neck. Maybe it was due to the cough, and then the defense will get all your prior medicals and try to use that against you. So it's very important to consider past medical records. Then there's the MRI findings, the actual where the injury is diagnosed, and then the force of the crash. How strong was the actual car crash? So let's get into the defense playbook. So this is the defense arguments, right? How defendants destroy cases. And so number one way they really love to destroy cases is to argue no damage, no win. Meaning, if there's not a lot of visible property damage to the car, it means you could not have gotten injured. And this is a really compelling argument because a lot of the jurors have been involved in little fender benders, right? Little taps, and then they think, look, I wasn't hurt. It was just a little fender bender. Maybe I'm parking and I touched the car. And so what they do is they show photos and they say, look, there's no damage to the car, so you could not have been injured. And that is a very, very persuasive argument. And the way to overcome that, sometimes you have to look at the property damage bill. Sometimes cars look normal because the bumpers, the way they're built, they just withstand up to 10 miles an hour of force, and there's no damage to the bumpers just because the way these cars are constructed. But there could be damage underneath. There could be damage to the actual undercarriage. So you have to sometimes speak to the mechanics or do a little bit of a deep dive. One way to also overcome it is to use this idea of, eggs. When you go to the supermarket, right, you buy a carton of eggs. Now the eggs are inside the carton, but people open up the carton and they want to look at the eggs to make sure they're not broken. But why would you need to look at the eggs if the carton is in good shape, right? The same as the car. If the car is in good shape, if the carton of eggs is in good shape, why do people find the need to open up the carton and look inside? Because, obviously you could have that whiplash injury. You could still get injured even without significant damage to one of the cars. So that's number one. Number two, another way the defense tries to destroy soft tissue cases is to say, if the plaintiff lies, the plaintiff loses. And what they really have to show is just one thing, right? Just one way that the plaintiff or the injured person lied about or gave an inconsistent statement. And sometimes it's very easy to find like one inconsistency because, people's memories aren't perfect, or people may say something in a deposition, but when they're testifying at trial, they may give a little bit different or a little bit what could be construed as inconsistent. And then that gets brought up by the defense. And then all they have to show is one. Because once they can show that you are lying, then your credibility can go down. And now the jury is the ultimate decider on the facts, right? That's their power. They decide the facts. The judge decides the law, make sure the law is being followed. But the jury is the ultimate arbiter and judge of the facts. So if they believe you're lying, even about one thing, they could dismiss the whole case. So that could be a very powerful defense playbook argument. Number three, what the defense could also argue is something known as falsus in uno. And it's actually right in the pattern jury instructions here in New York, where the judge will read this to the jury. And falsus in uno is a Latin phrase. The full phrase is actually falsus in uno, falsus in omnibus. And what it basically means is if you're lying about one thing, you may be lying about everything. And so the jury can choose not to believe any facts. They can just choose to not believe one fact. They could choose not to believe many facts, right? And it kind of similar with point number two. But the point is that, like, for example, if they don't like you, if they think you're lying, they can just choose not to believe your doctor. Even though you have this doctor who's an expert, right, and he's giving his or her medical opinion, they can say, you know what, I'm just going to ignore the doctor's opinion. I don't believe them because of the property damage or because the plaintiff was lying about when they started treatment or about the severity of their symptoms. Now they just toss out entire portions of your case, of your evidence, and that's allowed. Now, the jury cannot or is not supposed to ignore the law. That's known as jury nullification, right? When the jurors just ignore the law. They're supposed to follow the law, and that's not allowed. But with respect to the facts, they can ignore facts. So you have to be very careful about that. Now, the next thing that the defense likes to argue is something known as medical bills. Now, in New York, we don't really sue usually for medical bills because we have no fault. So the no fault pays for medical bills. And then we have a separate policy, which is bodily injury, that pays for pain and suffering, lost wages, things like that. But in many states, you sue for the medical bills. And so you have somebody get up on the stand and talk about all of the visits, how much they cost. And one of the things people will claim is physical therapy. And they'll say, look, I had to pay for all this physical therapy, for example, like the hot packs or the cold therapy. And what the defense likes to do is ask the plaintiff, maybe on cross-examination, hey, do you have like frozen peas in your freezer? And then the person might say, yeah, sure I do. And then they might say, oh, well, do you have like, are you able to get like maybe like a hot towel at home? You know, they might say, yeah, sure I can. And then in closing argument, they'll argue, wait a minute, well, if you have a hot towel, that's the same as the hot pack. And if you have frozen peas, you could just use that. So why are we paying all this money for all these medical bills, all these doctors trying to bill when you could just do it for free? You know, so you have to be careful with that kind of argument. And then the next big defense playbook argument is to say the plaintiff, the injured party, did not meet their burden of proof. And what they'll say is, look, you heard from a chiropractor and you heard from a pain management doctor in this trial. But wait a minute, the plaintiff was involved in a car crash. How come the police officer didn't come in? The police officer could have come in and testified. How come the EMT, the ambulance worker who arrived at the scene, didn't come to court? They could have called them to come to court. How come the emergency doctor from the hospital wasn't called to court? They could have called him. The plaintiff could have called him. He could have testified. You see what they're doing? What they're doing is they're basically saying that the plaintiff didn't meet their burden of proof and building up this burden as if it's such a burden. Like you need to call the police officer, you need to call the nurse, the hot people from the hospital. But in reality, you don't have to, right? And in reality, if somebody were to do all that, then a soft tissue case might end up costing a plaintiff like, $5,000 for this witness, $5,000 for that witness, and then it's just like an insurmountable burden. In reality, it's not the burden, right? It's not the same as in a criminal case where it's beyond a reasonable doubt. In a civil case, the burden is really simple. The burden is just, more likely true than not true, or the greater weight of the evidence. So whatever tips the scale, 51%. So it's a much simpler burden. And that's not really true. And another thing, what they like to do with that same argument about the burden of proof is in closing argument, they like to tell the jury, there could be 3 possible verdicts. Number 1, if you believe the plaintiff, you can find for the plaintiff. Number 2, if you believe the defendant, you can find for the defendant. But number 3, if you think, well, the plaintiff might be right, but they didn't really persuade me, it's more like a tie. Well, then ties go to the defendant, right? Because the plaintiff didn't meet their burden. They didn't tip the scale and prove what they need to prove. So then if it's just a tie, and that's also in the pattern jury instruction, it goes to the defendant. So those are the 3 possible outcomes, and they use that. And that's also very, very persuasive. And then the final way that I've seen in soft tissue cases where defendants try to get good cases dismissed is they argue delay in treatment. They say, look, the crash happened, plaintiff didn't call an ambulance, they didn't go to the hospital right away, they didn't go to urgent care, they didn't go anywhere the next day, they didn't go anywhere maybe for like a week or whatever the timeline was, and then they finally went to a doctor like, a week or 2 weeks later. Why is that? If they were really hurt, then they should have seen a doctor right away. And so some of the ways to counterbalance that, with respect to the property damage, like we talked about, there's ways to do it with the carton of eggs, or one lawyer I believe likes to do it where he puts a chair and then he walks across the courtroom quickly and he kicks the chair, and then he picks up the chair and he shows it to the jury and he says, look, there's no damage to this chair, but if somebody was sitting in that chair when I kicked it, you telling me that person could not have been hurt? There's a lot of different ways you could talk about the property damage. With respect to delay in treatment, I think the way to address that is in the voir dire. It's important for the plaintiff's attorney to ask, well, how many people have been injured before? And out of those who have been injured, how many of you didn't want to rush to the doctor right away? Like if you had an injury at night, did you go to the emergency room at night? And then many people might say, no, I didn't. Okay, and why didn't you? And then some of the jurors, you get the jurors talking, and you get the jurors to make your argument for you. You let them come to the conclusion, and they'll say, you know what, we didn't want to spend the money, or maybe other people needed the emergency room care more than me. I wasn't sure that it was really an emergency. I thought maybe it's just going to go away. And those are the same reasons that your injured client didn't go right away. And so you make the jurors make the case for you, and then when the defendant argues, oh, they delayed. Well, now the defendant is arguing not against you, but they're arguing against the jurors, right? Because the jurors came to this conclusion on their own. So that's a really powerful way to get around the delay in treatment. And then the other argument you can make as a plaintiff is you can say, look, something is actually wrong. Because what are they ultimately trying to say, right? The defendants, they're ultimately trying to say, if you didn't go to the doctor right away, it means you weren't hurt, and then you're a faker, right? You're a faker, you're a malingerer, you're making this whole thing up. So what you do is you say, look, something is actually wrong if you go to the emergency room right away before you can confirm that it's really needed. Now, if you just, have a little, something happens like a little car crash and you start running to the emergency room, well, then you're a faker. If you're really, truly hurt, then you wait and you think maybe it's going to go away. And when it doesn't go away, when you see there's a sign that this could be a real injury, a permanent injury, well, then I'm going to go a few days later and get checked out because, I've exhausted all my other options. So you kind of turn it around on them. So, but yeah, these are basically like the arguments. So that's the defense playbook. And then with respect to the plaintiff playbook, or the way to argue against it is, we could do another video about that. But in general, it's just really you have to get really specific. You have to get granular. You have to take every argument and really try to get to its core truth. Is this argument true? Sometimes you may have a case where it is just a little fender bender and there is no damage to the car. And, ultimately they may be right. But if you do have a case with maybe property damage that's not visible, but you have other proof and you do have a real injury, then that could easily be overcome. And then you could still win these soft tissue cases. So I hope this has been helpful. I think this is the defense playbook, and there are ways to overcome it. And these are some of the ways that a plaintiff can at least think about it, because once you know what the defendants are going to be talking about, then you can start building your response to it. And plus you can be thinking about what the defendants will say. Once you know what your opponent is going to say, you're much better prepared to deal with all of those issues. Okay, so I hope this has been helpful. Let us know what questions or comments you have. Please like and subscribe to our channel, and leave us your questions, leave us your comments, and we look forward to speaking with you very soon. Okay, have a good day.